Welcome back to One Stop Law. Now we come to the final element, that is the fifth element, which vitiates free consent to a contract, and that is mistake. Now, before we go into the specific provisions of the Indian Contract Act, let us look into the simple meaning of the term mistake, which is a wrong judgment. Okay, and it means an erroneous belief about something. So basically, mistake is when a person forms a wrong judgment and then he enters into a contract. Now let us look into the specific provisions under the Indian Contract Act. So now we see that sections 20, 21 and 22 of the Indian Contract Act provide for mistake, that is effect of mistake on free consent and consequently on the validity of the contract. Now if you remember, in my previous video I have told you, in my first video rather, I had told you that the effect of mistake on the contract is that the contract is not voidable like other elements, like if there is coercion, undue influence, fraud or misrepresentation, then the contract becomes voidable at the option of the party whose consent was caused by these factors. But when it is caused by mistake, then the contract is not voidable, rather it can be either valid or void. So let us look into the kinds of mistake and how does it affect the validity of a contract. So we see mistake is broadly of two kinds, mistake of law and mistake of fact. Now under mistake of law, it is provided under section 21. Again, mistake can be of two kinds of law, that is, one is the mistake of the native law, that is the law of the land. In our case it is the law of India, the Indian law, mistake of Indian law, and the other can be mistake of foreign law. Both the provisions have been provided under section 21, and it says that if there is a mistake of Indian law, that is the native law, then the contract remains valid, and this is based on the maxim ignorantia juris non excusat. I will deal with it in details subsequently. And in case of mistake of foreign law, whether it will be valid or void will depend on the consequence, as it is treated as a mistake of fact. So next we look at the other kind of mistake, that is mistake of fact. So mistake of foreign law is treated as a mistake of fact. Mistake of fact can again be of two kinds. It can be a bilateral mistake and an unilateral mistake. Bilateral mistake is provided under section 20 and unilateral mistake is provided under section 22. Effect of bilateral mistake on a contract is that the contract becomes void, and that of an unilateral mistake is that the contract remains enforceable, that is, it remains a valid contract. Now I will deal with all these kinds of mistakes one by one in my subsequent slides. Now the first kind of mistake that is provided under the Indian Contract Act is about mistake of law. Now what is mistake of law? Mistake of law means the parties who enter into the contract makes a mistake as to the law concerned with that particular contract. Okay, so on that basis, mistake of law can again be of two categories. One is the mistake of the law of the land, law of the country, that is the country in which they live in, the parties live in. And the second is if they make a mistake about a foreign law, so they are dealing with a foreign law and they make a mistake on that. Now the first kind, that is the mistake of law, where it is the mistake of the law of the land, law of the country, we call it the native law. It is basically based on a Latin maxim which we call that ignorantia juris non excusat, that is, ignorance of law is no excuse, period. There is no excuse to that. So suppose someone, I will give you first an example, a simple example, that is, suppose a person steals someone's belongings or property, and then he says, oh, I didn't know that theft is an offense in this country, please pardon me, I did it without knowingly, without having any knowledge that theft is an offense in that country. Will law excuse that person? No. Being a citizen of the country, you cannot be unaware of the law of the land, rather you cannot claim the excuse that you didn't know the law of the land. The same effect is given to contract. If the parties who enter into a contract, after making the contract, claim that one was under the impression that the law was something else, and it was under his mistake, he had made a mistake, he had a mistaken belief about the law concerning that contract, then if that law is the Indian law, then the person cannot claim any excuse and he has to bear the consequence of the contract, and the contract will be treated as a valid contract. Okay, so as you can see, it is written, a party cannot be allowed to get any relief on the ground that he had done a particular act in ignorance of law. A mistake of law is therefore no excuse and the contract cannot be avoided. You can see there is an example. A and B enter into a contract on the erroneous belief that a particular debt is barred by the Indian law of limitation. This contract is not voidable. They thought that the debt is barred by limitation. That is their headache, their problem. The contract is enforceable, and whoever gets the, whoever has the claim over the contract money should get it from the court. However, if the mistake is about a foreign law, suppose A and B making a contract based on some law of a foreign country, say the law is of Germany, and then A is under some wrong impression, some mistaken impression about that German law. Then what happens to that contract? Because in this case the law is not of India, A and B are Indians, but the contract they are entering into is based on a German law, and A has made a mistake about the German law. In this case, it will be treated as a mistake of fact, and then the consequences will be as such, what we will learn in our subsequent slides about the effect of mistake of fact on a contract. Okay. Now I won't make this video too long, so I will stop here after discussing mistake of law, and we just learned that mistake of Indian law is no excuse and the contract remains valid and one has to bear with its consequence, whereas if it is a foreign law then it is treated as a mistake of fact. So in our next video we will learn about mistake of fact in details and its two kinds, that is bilateral mistake and unilateral mistake, and their effect on the validity of the contract. That's all. Thank you.